+2 വരെ കോട്ടയം ലൂർ പബ്ലിക് സ്കൂൾ ആൻഡ് ജൂനിയർ കോളേജിൽ വിദ്യാഭ്യാസം. സെക്കൻഡറി ടോപ്പറായി +2 ജയിച്ചു. സിവിൽ സർവീസ് ആയിരുന്നു ലക്ഷ്യം. അതിനുവേണ്ടിയാണ് ഈ കോളേജിൽ നിയമപഠനത്തിന് ചേർന്നത്. അസുഖബാധിത തുടർന്ന് ഒരു പിടി സ്വപ്നങ്ങൾ ബാക്കിയാക്കി 2015 നവംബർ 30 വിധിക്ക് കീഴടങ്ങി. കാലം എത്ര കഴിഞ്ഞാലും നവമി, നിന്റെ ഓർമ്മകൾ ഞങ്ങളിൽ നിന്നും പ്രകാശിക്കും. വിടരും മുമ്പേ കൊഴിഞ്ഞ പൂവിതളായി ഞങ്ങളോടൊപ്പം നീയും നിന്റെ ഓർമ്മകളും എന്നും ഉണ്ടാവും. Coming together is beginning. Keeping together is progress. Working together is success. A warm welcome to sing our eyes for a moment of silence, a moment of seeking blessings. I invite Vani Devi, 3-year first semester student to lead. I invite Vani Devi, 3-year first semester student to lead us into prayer.
പുലരിയിൽ വിരിയും സുമം, സന്ധ്യയിൽ പൊഴിയും ദ്രുതം, ക്ഷണികമെങ്കിലും അനുപമം, അഴകിലവയൊരുക്കിടും പരമജ്ഞാനമേ ദൈവമേ, കൈവണങ്ങി നമിപ്പു ഞാൻ. പുലരിയിൽ വിരിയും സുമം, സന്ധ്യയിൽ പൊഴിയും ദ്രുതം, ക്ഷണികമെങ്കിലും അനുപമം, അഴകിലവയൊരുക്കിടും പരമജ്ഞാനമേ ദൈവമേ, കൈവണങ്ങി നമിപ്പു ഞാൻ, കൈവണങ്ങി നമിപ്പു ഞാൻ.
Now I request all our esteemed guests to come forward to light the lamp.
Now I request all esteemed guests to be seated on the dais. Sunshine is a welcome thing. It brings a lot of brightness. Your hard work is the foundation for our achievement. I welcome the sunshine and lamp of our institution, Mr. Koshi Abraham Bursar, CSI College for Legal Studies, for the welcome address.
Respected Reverend Gigi John Jacob Bachchan, Professor Dr. D. Surya Prakash Rao, Professor Dr. Bismi Gopalakrishnan, Advocate Sunny George Chathakulam, Principal Dr. George Joseph Sir, Vice Principal Dr. JC Ma'am, dear teachers and students, warm welcome to everyone. Today we are conducting our 7th annual law lecture and Navomy Endowment Award ceremony. I am sure that the participation in today's program will help our students and teachers in many ways. We encourage you to take full advantage of these sessions and participate actively. Today's meeting is presided by Reverend Gigi John Jacob Bachchan. He is the treasurer of CSI Madhyakarla Diocese. He gladly accepted our invitation and presiding this function. Thank you, Achan, for your presence, and it is a great honor for me to welcome you to this function. Today's function will be inaugurated by Professor Dr. Bismi Gopalakrishnan. She is the first woman registrar of Mahatma Gandhi University. Dr. Bismi Gopalakrishnan holds multiple roles, including Director of Research at MG University. On behalf of CSI College for Legal Studies, I proudly welcome you, ma'am. The annual law lecture will be delivered by the Honorable Vice Chancellor of DSNLU, Professor Dr. D. Surya Prakash Rao. He also served as principal of the prestigious oldest law college, Dr. B.R. Ambedkar College of Law, Andhra University. He received several awards like Andhra Pradesh State Best Teacher Award, Best Research Award of Andhra University, etc. He has successfully guided more than 60 PhD scholars in law, and more than 30 research scholars are pursuing PhD in law under his guidance. Even though he is busy with many other scheduled programs, he accepted our invitation and attending this function. On behalf of CSI College for Legal Studies, I proudly welcome you, sir. His wife, Mrs. Surya Prakash Rao, also is attending this function. Thank you, ma'am, and we welcome you to this function. I also extend a warm welcome to Advocate Sunny George Chathakulam, former district government leader and public prosecutor. We warmly welcome you, sir. It is my pleasure to welcome our principal, Professor Dr. George Joseph Sir, and Vice Principal Dr. JC Ma'am to this event. I thank both of you for your guidance and support to make this event a successful one. I also welcome the parents of Navomy, Mr. Thomas Matthew and family, who instituted the Navomy Endowment. It is our pleasure to welcome all the rank holders and endowment awardees. I also extend a warm welcome to the friends from the media. Last but not the least, I welcome our adored teachers, non-teaching staff, and our precious students to this event. I congratulate all the award winners and our teachers who prepared our students to achieve these awards. Thank you all once again, and have a great event. Thank you.
Thank you, sir, for the welcome address. A great scholar builds character, inspires dream, encourages creativity, builds confidence, instills a lot of learning, touches our heart deeply. He is a visionary leader who guides our institution to new heights of excellence. So I invite Professor Dr. Joe Joseph, sir, Principal, CSI College for Legal Studies, for introduction of annual law lecture and Navomy Endowment Award.
Paying my rich tribute and homage to the departed soul of Navomy, our student and beloved doctor of Mrs. and Mr. Thomas Matthew Kottayam. Friends, may I begin? Every year we used to conduct a series of lectures with the beginning of annual law lecture. This is the 7th one. We are conducting it in the year 2025. I have the privilege and honor of saying a few words about what is this annual law lecture, what for this annual law lecture, and what for this endowment, and how it is being conducted here for the last 7-8 years. Respected chair of the function, Reverend Gigi George Jacob Achan, Honorable Vice Chancellor of National Law University of Visakhapatnam, Professor Dr. Prakash Rao, esteemed Registrar of Mahatma Gandhi University, Professor Dr. Bismi Gopalakrishnan, distinguished invitee, Advocate Sunday George Chathukulam, former district government pleader and public prosecutor, KOTTAYAM, our beloved Vice Principal, Dr. J.C. Karingatil, the man behind all this, executing this function, our esteemed bursar of this college, Mr. Koshi Abraham, faculties, distinguished invitees, friends from my media, and my dear students. This annual lecture is intended for the exclusive purpose of inviting distinguished legal luminaries of this country. Thereby, their experience and their expertise will share with you directly in person, and you will be illuminated, enlightened, and provoked and boosted up. That is our foremost intention behind conducting this annual law lecture. For the chief guest and the registrar particularly, I have the pleasure of informing all of you and to them that this is the only college in the state of Kerala conducting this annual lecture program, inviting distinguished luminaries in this country. Previous lectures were delivered by vice chancellors of different national universities, Patna Vice Chancellor, then National University Vice Chancellor Goa, then Vice Chancellor from Delhi University, Local Commission of India member. Like that it goes on. And today we have the distinguished personality before us, that is Professor Dr. Surya Prakash Rao. I need not mention much about him because at the time of comparing, you will get the brief profile of his history. An experienced scholar and a legal expert in different branches of law, having about 40 years of experience, is before you to deliver the lecture on the topic assigned to him, chosen by him for the purpose of disseminating to you the topic which you are studying in the constitution, that is constitutional challenges. What are the mechanisms for that? He will be delivering on that aspect while delivering the annual law lecture. Now, the endowment lecture, as you have heard from the welcome address, you have heard that, like you, 9 years before, by name Navomy joined here, but the destiny didn't allow her to continue to live in this world. She is with us in the abode, in the heaven. To her memory, the parents of Navomy and Thomas, Mrs. and Mr. Thomas Ottayaam and family, executed an endowment in the name of her beloved daughter. Because of the charity and generosity and the magnanimity, we are organizing every year this function. We are gracious to them, and I particularly express my sincere sincere thanks for coming over here, even as part from their physical weakness and other busy schedules in their daily life. Every year they used to come here. They have only instituted this program, but they never miss a chance because of any reason or any other reason. So, and in the name of Navomy, we are awarding certificates to the first semester students who secured highest mark in BLLB and become LLB. That is the bond they have executed with us in the university, not the 3-year students. 3-year only we have recently started to a 1-year back. And the award, certificate as well as award in the name of Navomy Endowment, executed by them. Then other certificates, etc., we are distributing for the different branch holders. That is also a unique feature of this college, particularly for the information of the chief guest. Though there are 7-8 law colleges under Mahatma Gandhi University, almost every year we are getting, I do not know what is reason, 4 or 5 ranks, without which this college, after coming over here from my tenure here, I am happy to announce to you and inform you that this is the college getting the highest rank in the examinations for the last 5 years. To some also the award is, this certificate mementos are provided. With these few words, I conclude with my extending again my personal welcome to the chief guest, Professor Dr. Surya Prakash Rao, all the way from National Law University, Visakhapatnam. He came over here, and our beloved registrar, Mahatma Gandhi, a very busy scheduled person. I invite, every year we used to invite Mahatma Gandhi University Vice Chancellor. Those who have attended last year, they know. But I also informed her, we used to invite the Vice Chancellor. Since you are the law professor and a distinguished identity in attending all national, international conferences and papers and books, etc., you must be the fit person for all this year, you must come. She readily agreed. Why, sir, you came? You should have called me. Only yesterday also. Yesterday I went there to hand over the invitation letter. There also, that time also she was telling like that. That is our affection and attachment to our college and to you as well as to us. On behalf of, again, I welcoming both of them. On my behalf and behalf of the entire CSI's family, I extend a warm welcome and I conclude. Thank you once again all.
Thank you, sir, for setting a rough sketch for the rest of the event. Now I welcome Reverend Gigi John Jacob Bachchan, Treasurer CSI Madhigala Diocese, for delivering presidential address.
Respected Principal of the College, Dr. George Joseph, Chief Guest, Professor Dr. D. Suryaprakash Rao, the Honorable Vice Chancellor of National Law University, Visakhapatnam, Registrar of MG University, Dr. Bismi Gopalakrishnan, Advocate Sunny George Chathugulam, Dr. JCT, the Vice Principal, Mr. Koshi Abraham, College Bursar, esteemed faculty members, well-wishers, and dear students. Good morning and a warm welcome to you all, those who are attending today's program. It is both a honor and privilege to stand before you as we gather together for the 7th annual law lecture and Navomy Endowment Award ceremony at the CSI College of Legal Studies. This institution, under the patronage of CSI Madhigala Diocese, has been a beacon of legal education, nurturing minds that will go on to make significant contributions to the legal landscape of our country. Legal education is not just about learning statutes, principles, and precedents, but it is about understanding the essence of justice, the rights of individuals, and the welfare of society. In this regard, institutions like our college play a pivotal role in shaping future lawyers, leaders, and advocates who will contribute to society in profound ways. Today, as we are about to engage in an intellectual and academic discourse, let us remind ourselves of the noble purpose behind the study of law. Law, at its core, is a tool for justice, equality, and protection of human dignity. It serves as the foundation of a democratic society, safeguarding the rights of individuals while ensuring that the wheels of justice turn with impartiality. Whether in the courtrooms, in policy making, or in daily life of the common citizen, the law guides and influences every aspect of our lives. At the College of Legal Studies, our commitment to academic excellence is matched by a deep sense of social responsibility. We believe that as legal professionals, it is not enough to simply understand the law. We must also live by its highest ideals. Our mission is not only to educate, but also to inspire a sense of service to humanity, to advocate for the marginalized, and to ensure that justice is available to all, regardless of their background and status. To our dear students, you are the future of the legal profession. As you continue your journey in law, I urge you to not only to strive for academic excellence, but to imbibe values of integrity, equality, and respect for human rights. In times of challenge and change, It will be these values that will guide you as you advocate for justice and contribute to society in meaningful ways. Before I conclude, I would like to express my gratitude to the principal, vice principal, bursar, faculty members, and the staff of the college who work tirelessly to ensure that this institution remains a nurturing ground for future legal professionals. I also thank our chief guests for accepting our invitation and sharing their valuable time and wisdom with us today. I hope that this lecture will ignite in all of us a renewed commitment to the pursuit of justice, the upholding of human rights, and the betterment of society through the practice of law. Let us continue to strive towards a world where justice is not a privilege for the few, but a right for all. Thank you, and I wish you all a fruitful and engaging session ahead. May God bless our endeavors. Thank you.
Thank you, Acha. It holds a great privilege to have the presence of Professor Dr. Bismi Gopalakrishnan, who is a true leader and an inspiration to us. Dr. Bismi Gopalakrishnan marks a milestone in MG University's history as its first woman registrar. She holds multiple roles, including Head of School of Indian Legal Thought and the Department of Lifelong Learning and Extension, as well as Director of Research at MG University. Her academic journey has been marked by numerous distinguished roles at MG University, including serving syndicate member and dean. Additionally, she has been selected for the U.S. Department of State Bureau of Education and Cultural Affairs International Visitor Leadership Program. It is a privilege for all of us gathered here to have such an eminent person. So I call upon Professor Dr. Bismi Gopalakrishnan, Registrar MG University, for inaugural address.
Paying homage to the memory of Navomy, most respected chair of the session, Reverend Gigi John Jacob, Treasurer CSI Madhya Kerala Diocese, Honorable Vice Chancellor Professor Dr. D. Surya Prakash Rao, National Law University, Visakhapatnam, most respected Professor Dr. George Joseph Sir, Principal CSI College of Legal Studies, Mr. Koshi Abraham, Bursar CSI College of Law for Legal Studies, Advocate Sunny George Chatukulam, former District Government Leader and Public Prosecutor, Kottayam, Dr. J.C. T., the Vice Principal of CSI College for Legal Studies, dear Rajesh Sir, dear Chaitanya, all the teachers of CSI College, the students of CSI College, the rank holders, and parents of Navomy. I'm grateful to Professor George Joseph Sir, Principal CSI Law College, for conferring upon me the honor for delivering the inaugural address at the 7th day law lecture. Our scholastic growth depends upon the company we keep, whether it's the teachers, whether it is the friends or our colleagues. It is indeed a proud moment to share this dais with Honorable Vice Chancellor Professor Dr. Surya Prakash Rao, DSS National University, Visakhapatnam, a legal scholar of universal eminence who has blazed his own trail in legal academics. This Law Day lecture focuses on evolution of constitutional jurisprudence for challenges to constitutional fundamentals. Development of constitutional jurisprudence is evolutionary, as all of you will be aware. It evolves over times to address new challenges and societal changes. This process involves amendments, judicial interpretations, and conventions. The Constituent Assembly, as all of us are always students of Constitution, and the Constituent Assembly had its first sitting on 6th December 1946. On August 29, 1947, after India attained independence, the Constituent Assembly appointed a drafting committee which submitted the draft constitution in February 1948. After extensive discussion and various amendments, it was adopted by the Constituent Assembly on November 26, 1949. The result was a most elaborate constitution in the world for perhaps the most diverse group of people of different religion, of ethnic backgrounds and language. It would be incorrect to give full credit to the Constituent Assembly, for they did not draft the Constitution from the scratch. The foundation for the new Constitution was the Government of India Act 1935, and important portions were added, especially the preamble and the chapters on fundamental rights and directive principles of state policy. The chapter on fundamental rights is perhaps the most glorious part of the Constitution, which also provide for an elaborate judicial system to protect these rights. Before Indian independence, India had a complex hierarchy of court system, especially administering the civil and the criminal laws, although the executive was not fully separated from the judiciary. The Constituent Assembly decided to continue with this, especially and also to continue with the federal system with a strong parliament at the center. The 7th schedule set out the fields of legislation for the parliament, that is list 1, the state legislature in list 2, and the concurrent list in the list 3, which stipulates fields wherein both the parliament and the state legislature could make laws subject, of course, to the primary approval of the parliament. The final product was a beautiful, a magnificent constitution which provided the framework for good governance and enabled all persons in India to achieve their dreams without forfeiting the basic human rights. On 26 January 1950, we gave ourselves the noble Constitution. 75 years later, the Constitution has survived, enabling us to enjoy our basic human rights, our basic freedoms that are virtually non-existent in many other third world countries. Many fundamental constitutional developments have occurred in various areas of constitutional law, and the most exciting aspect is that there are areas in which the Constitution was not even being amended. Many of the evolutionary decisions are not being determined by the constitutional text being amended. Instead, they are the result of judicial pronouncements. The Supreme Court articulated somewhat different pronouncements, and entirely new path-breaking judgments was being made by the Supreme Court to meet the demands of the ever-changing legal, political, economic, and social world. I recollect the term juritocracy, which has been coined by Professor Rand Hrenschel, the Canadian scholar, who described the significant role that judiciary equipped with unprecedented power in many constitutional democracies. The Supreme Court of India, an institution that has come to fit perfectly in this particular groove, utilizing its good sense to tackle issues ranging from human rights, town planning, forest management, rent control, multipurpose dams, special economic zones, the third gender issues, elections, reservations, parliamentary privileges, and even, again, the reviewing the constitutional amendments. The basic structure doctrine has repeatedly saved the integrity and security of the Constitution. And definitely remembering Keshavananda, I.R. Coelho, Indra Swani, and many such judgments. this is the situation in other jurisdictions also, because how can ever one forget the blockbuster decisions, especially of the Warren Court, where the Brown versus Board of Education, Mapp versus Ohio, Griswold versus Connecticut, and Miranda versus Arizona, which has a real constitutional effect on the real world of America. Now, in this contemporary times, debates on traditional rule of law, sovereignty, separation of powers, secularism, parliamentary privileges, role of executive are really on debate. And also, we are pondering upon the self-inflicted wounds on the Constitution is also being reviewed with new vigor. In this context, let me congratulate Professor George Joseph Sir and the entire family of CSI Law College to organize a Law Day lecture on a topic of contemporary relevance. I can only conclude with the words of Joseph's story that was quoted by Sachidananda Sinha in his inaugural address as a provisional chairman of the Constituent Assembly on 6th December 1946. I quote, "The structure has been erected by architects of consummate skill and fidelity. Its foundations are strong. Its compartments are beautiful as well as useful. Its arrangements are full of wisdom and order, and its defenses are impregnable from without. It has been reared for immortality. If the work of man may justly aspire to such a title, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. Republics are created. These are the words which I commend to you for your consideration by the virtue, public spirit and intelligence of the citizens. They fall when the wise are banished from the public councils because they dare to be honest, and the profligate are rewarded because they flatter the people in order to betray them." Thank you.
Thank you, ma'am, for your insightful words. Professor Dr. D. Surya Prakash Rao has been the Vice Chancellor of Damodaram Sanjeevayana National Law University, Visakhapatnam. He served as Professor at Maharashtra National Law University, Nagpur, and Principal of Dr. B.R. Ambedkar College of Law, Andhra University, where he served in various leadership roles with 36 years of teaching experience, including 18 years as Professor of Law. He specializes in jurisprudence, constitutional law, human rights law, and more. He has published over 60 research articles, authored a book, and presented papers at more than 200 national and international seminars. He has guided more than 60 PhD scholars and coordinated various academic programs in human rights and law. With great pleasure, I invite Professor Dr. D. Surya Prakash Rao for the 7th annual law lecture on the topic Evolution of Constitutional Jurisprudence for the Challenges to Constitutional Fundamentals.
Thank you, madam. Good morning to all of you. Respected Chair, Reverend G.G. John Jacob, Professor Bismi Gopal Krishna, Registrar Mahatma Gandhi University, and Advocate Sunny George Chatukulam, then Mr. Kushi Abraham and Professor George Joseph, other dignitaries on the dais and off the dais, invitees, teachers, student friends. I deem it a privilege to associate with this prestigious institution, and I am honored to give special lecture on the evolution of constitutional jurisprudence for challenges to constitutional fundamentals. In her inaugural address, Professor Dr. Bismi Gopalakrishnan touched everywhere constitutional fundamentals, challenges, and solutions taken from American justice system to the Indian constitutional system and the evolution of constitutional jurisprudence by the Indian judiciary right from 1950 to 2025, 75 years experience as a constitutional court. Supreme Court of India faced several challenges, as Professor Bismi Gopalakrishnan just mentioned about the suffering of Supreme Court of India with self-inflicted wounds by giving some type of narrow interpretation without raising to the occasion to the national challenge. However, as we know, the evolution of constitutional jurisprudence, we know the history, how the 5,000 more years Indian civilization was encrypted into the constitutional culture through the constitutional making process and the contribution of Constituent Assembly, particularly Dr. B.R. Ambedkar as chairman of the drafting committee and B.N. Rao as constitutional advisor and other members of the constitutional drafting committee and various members who actively involved in the debates on each and every objective clauses and a specific article discussion. So, when we talk of constitutional jurisprudence, how it was evolved and how it raises to the occasion to face the challenges to the constitutional fundamentals. And of course, we have a strong, rich heritage, and in the initial stage, when we had these 16 Mahajanapadas, which can be equated to Greek city-states, where each and every state, Greek city-state republics, each and every city itself is a republic. Like that, we had 16 Mahajanapadas in northern India, where republican form of governments were there, where the king was elected by the people. Until Magadhan ascendancy, Magadha was emerged as a mighty authoritarian power. From Magadhan ascendancy as mighty authoritarian power, we had dynasty after dynasty, invasion after invasion, and different cultures were encrypted into the main culture of Indian civilization. So we know how the jurisprudence was evolved, how the law was evolved. So initially, because of the authoritarian form of governments, we have rule of man. So the human civilizations moved from rule of man to rule of law. So in the recent past, rule of law was further dynamically interpreted for providing rule of life. So if rule of law fails, if democracy fails in a modern civilized political state, utter anarchy, when there are no governments, strong governments, we are observing and we are experiencing different international events like the failure of international law, and of course, ultimately, the morality plays an important role. So here, how the constitutional jurisprudence was developed. Constitutional jurisprudence are what we say constitutional fundamentals, constitutional culture, constitutional morality, constitutional legitimacy. So the legitimate expectations of the people, how they are addressed by the constitutional system. So the constitutional making process in India gave us the idea that various constitutional fundamentals were incorporated in the Indian constitutional system. Take for example the impact of various other constitutions on the Indian constitution making. If you take the written constitutional model, constitutional supremacy, Bill of Rights, judicial review, all these were taken from American constitutional experience. Before Indian constitutional makers, we have 150 years experience, American constitutional experience was there before the constitutional makers. And of course, the oldest democracy in modern political states, Britain is the oldest democracy where even though it has no written constitutional model, even though it has no republican form of government, it has its own rule of law. So when Britishers came India and occupied India and made India as a colony, they introduced their rule of law. So they reformed the Indian public law. So they brought codification of the Indian laws. Of course, the impact of the codification of Hindu era, the impact of other laws were there. That's why Henry Maine in one occasion made a comment. The failure of Hindu law is the success of Rama law. The reason was Hindu law was at appropriate time was codified by way of Smritis, Aranyakas, Upanishads, Narada Smriti, Parashara Smriti, Yajnavalkya Smriti. So a concise code of Yajnavalkya Smriti was brought in 12th century. That is Mitakshara. So that's why at an appropriate time, the law is to be codified and recodified. The reason is law keeps on changing with the changing needs of the society as it is part of social reality. So here, because there was no scope for Indians particularly to recodify, to rectify the social evils encrypted into the system, Hindu law was the failure. So until Raja Ram Mohan Rai came, until Lord Bentinck brought that reform, Sati Sahagamana, a social evil encrypted into the Hindu system, was not rectified. So human sacrifices which were legalized were also banned by the British government. So of course under 1833 charter we have a codification process. The modern legal system was made right from 1833 charter by Lord Macaulay, who was made the member of the charter, a law commission member. So the real codification process in India was started in the name of Contract Act, Indian Penal Code 1860, and all these things are there. But at an appropriate time, those were brought and amended to make them suitable to the contemporary Indian society. So that is one aspect. So as far as constitutional fundamentals are concerned, we had taken rule of law and parliamentary form of government from Britain government, Britain constitution. From Irish constitution we have directive principles of state policy. From Japanese constitution, particularly when B.N. Rao, Sir B.N. Rao, the constitutional advisor and who was also the architect of Government of India Act 1935, visited several countries on behalf of drafting committee and consulted various legal experts. So in the process, he met Justice Frankfurter, who was a professor turned judge. Frankfurter advised B.N. Rao on two articles. Article 19, because there were no restrictions specified in American Constitution, the ambiguity of interpretation was there, so you please specify the restrictions. Of course, that restrictions were softened by Indian judiciary by developing the doctrine reasonable classification, reasonable restrictions. Restrictions imposed by the government should not be allowed and accepted. If it is reasonable restriction on the freedoms guaranteed under Article 19, let them allow. So regarding Article 21 also, Justice Frankfurter gave a concretized practical advice. Instead of due process, you take procedure established by law. So here, because of the limited interpretations of that particular phrase, in India, judiciary was not able to protect the liberty until Maneka Gandhi case. Because of that procedure established by law, the limited literal, grammatical, legalistic approach adopted by the court did not give adequate protection to the liberty until Maneka Gandhi. And here that's why constitutional fundamentals, Madam also referred, fundamental right chapter, directive principles of state policy, fundamental duties. These are the areas where we had constitutionalism. Constitutionalism promotes transparency, accountability, and limited government. Constitutionalism is antithesis of arbitrariness, authoritarian form of government, and unaccountability. Constitutionalism demands accountability. So these three parts, along with constitutional preambular declaration, we had a safety mechanism. But how this safety mechanism was to be understood, construed, and interpreted for the dynamic interpretation of the constitutional process. So that's why regarding constitutional fundamentals, we may say single citizenship, fundamental rights, directive principles, parliamentary form of government, and judicial review, written constitutional supremacy. Of course, when there was a debate between parliamentary supremacy or constitutional supremacy, in Keshavananda Bharati, Supreme Court was able to protect constitutional supremacy through Keshavananda Bharati decision in 1973. So these are all the constitutional fundamentals, independent election commission and healthy federal relations. Of course, the constitutional makers know pretty well about making Indian federalism with strong center bias. So in those days when the independence came, when constitution was in the process, making process, so the national security was at doldrums. So that's why constitutional makers made Indian constitution as more strong center biased constitution. But through its dynamic interpretation, the Supreme Court of India now made the federalism in a true federal character. So at one time, Article 356 was misused, overused, and that practice, which was against the constitutional morality, was stopped by Supreme Court in S.R. Bombay versus Union of India. From then onwards, it is very difficult to impose Article 356. Even it is imposed, various checks and balances are there to continue it. So these are all possible because of the dynamic interpretation of the Supreme Court. But in the evolution of understanding the challenges to constitutional fundamentals and how the judiciary overcome and made the legislature and executive accountable to the constitution is very interesting. And of course, these fundamentals are there, and we have directives, we have fundamental rights. So if you take the initial interpretation, fundamental rights were understood as enforceable rights under Article 13, whereas directives were understood as non-enforceable rights under Article 37. But in the evolution of constitutional jurisprudence, Supreme Court of India was successful to maintain balance between fundamental rights and directive principles of state policy. By 1980, in Minerva Mills versus Union of India, Supreme Court was successful to provide balance between fundamental rights and directive principles of state policy. So, like that, whenever there is a controversy, Supreme Court tried to solve the controversy, balancing the conflicting interests among the conflicting groups. You know, for that, the constitutional jurisprudence, you know what is law? Law is a regulator to regulate the affairs between two individuals in the society in one aspect. Law is a regulator to regulate the affairs between individual and the society. In third aspect, law is regulator to regulate the affairs between individual and political state. The political relationship between individual and the state is regulated through the Constitution of India. So we are trying to understand the political relationship of the citizen with the state through constitutional jurisprudence. So in that aspect, we had a model. After having taken different constitutional experiences, Indian constitutional makers provided us a Constitution of India suitable to the Indian conditions. So, a constitution is, after all, a theory of rights. So, different rights of different people through different theories are amalgamated, are adjusted, are accommodated under constitutional system. So, you take women's rights, you take child rights, you take aged people rights, you take underprivileged rights. You have 15 class 4, 16 class 4, and the evolution of reservation jurisprudence also. If you take note of evolution of reservation jurisprudence, you go to this particular, the issue regarding reservation is twofold. What is the ratio of reservation? Whether it is 50% reservation, beyond 50. Sometimes judges accepted 60%, 65%, 70% also. But all these are from Balaji versus State of Mysore to Vasanta Kumar, one phase of interpretation of reservations. From Vasanta Kumar to Indra Shahani, popularly known as Mandal case, different type of interpretation. So in Mandal case, these two issues were resolved. What is the criteria to identify the backwardness of a particular person? Because reservations are authorized to socially and educationally backward classes. Of course, recently, court tried to accommodate the economically backward classes also, approving the 10% of reservation provided by government, which was once rejected by the same court in Indra Shahani case. In Mandal case, when P.V. Narasimha government provided 10% reservation to economically backward classes, was not accepted, but now it is accepted. Of course, so regarding reservations, 50% was fixed, and identification of backward class, creamy layer test was adopted in Indra Shahani. So like that, if you go to freedoms, so different level of freedoms were interpreted, particularly 66A, Information Technology Act, which was struck down. The reason is freedom of expression is not a single interpretation. So for some people, that expression may be identified as valid. For some people, it is objectionable. So that type of liberal accommodation was permitted by the court. And in Right to Information Act, 66A was struck down. So like that, regarding Article 21, the dynamics of Article 21 from Gopalan to Manaka Gandhi, post-Manaka scenario, and particularly the suspension of fundamental rights during national emergency under Article 352 and 358. That was initially allowed, which was considered as self-inflicted wounds. I want water. So, Indian Supreme Court adopted several dimensions of understanding the law. Law as dictate of reason particularly, which was further molded from the previous thought of law as dictate of nature, dictate of God. So ultimately that thought was further processed and developed by Immanuel Kant, who is still relevant regarding understanding and evolution of various doctrines by the Supreme Court of India in the dynamics of Article 14, dynamics of Article 19, dynamics of Article 21. Reasonable classification. Classification should not be unreasonable, should not be arbitrary. So Immanuel Kant says law is dictate of reason. Law is categorical imperative. So he was able to classify categorical imperative, which is common among all the people, apart from hypothetical impulses. So Neo-Kantians, Kant and their theory of reason. So for them, freedom is the fulcrum of the rights of the people. So we also know the history and evolution of constitutional jurisprudence today regarding right to property also. For some period, right to property was considered as a sacrosanct value. So the people who had Oxbridge trained culture, judges or politicians or legislators or executive, they gave more importance to property. Unless a person has property, how can he enjoy the other rights? That was the concept. Then the theory of property was changed in such way, property to few people or property, minimum property to satisfy the needs of the people for all people. So in that concept, even Article 31C, which prevents the prevention of concentration of economic power and material resources redistribution, was accepted by the court. So court also shifted from giving sacrosanct value to right to property to the extent of allowing the abolition of right to property as a fundamental right. Now right to fundamental right through 44th constitutional amendment is only a constitutional right under Article 300A. That was accepted by the court. The reason is the reasonable classification is the strength of dynamic interpretation of Article 14. Reasonable restrictions is the strength of the dynamic interpretation of Article 19. If you go to the Article 21, law should not be any draconian law. It should be just, fair and reasonable. That's why the reasonable classification, reasonable restrictions, reasonable law, just and fair law are the present important instruments of constitutional jurisprudence. With the help of these strong constitutional instruments, the Supreme Court was able to protect the constitutional fundamentals. Supreme Court was able to discard the constitutional challenges. Madam referred that particular Brown versus Board of Education. So prior to that, Plessy versus Ferguson, where equality was interpreted in a restrictive way by the Supreme Court. Equality means equality but separate. From 1873, Plessy versus Ferguson, to Brown versus Board of Education in 1958. In America, true equality was not implemented. Equality but separate was implemented. When there were 100 schools for white students, corresponding 100 schools were permitted to be opened for black students. But black student was not allowed to study along with the white people in white schools. Equality but separate. Only in Brown versus Board of Education, Warren Court, of course, 6 months prior to the actual judgment, jury matrix was also conducted, and what type of judgment the judges are going to give. The result was, judges are going to give unanimous judgment to overrule Plessy versus Ferguson. Equality means equality. Equality but separate is inequality. That is the crux of the judgment, which has been being implemented in Indian soil through the constitutional system right from 1950. So that is the strength of the Indian Constitution. Of course, we have separation of powers in principle. Legislature is given a specific role, executive is given a specific role, judiciary is given the topmost role, because you have judicial review under Article 13, you have 32 fundamental rights are made as the enforceable right to the people, and corresponding duty is imposed on the apex court. Supreme Court of India is the chief custodian of the fundamental rights. Article 32. But unfortunately, during emergency in habeas corpus case, ADM Jabalpur versus Shaukan Sokla, during emergency fundamental rights were suspended, including coming to the Supreme Court under Article 32, contending that fundamental right was violated. Of course, that only H.R. Khanna, Justice H.R. Khanna, through his minority judgment, understands the value of the fundamental rights, the value of the protection of fundamental rights. That is overruled particularly in Manakka Gandhi. Now we have the dynamic role of Supreme Court. Of course, in post-Manakka only, several liberal dynamic interpretations came from Supreme Court, awarding compensation to the victims of gross violation of fundamental rights. Initially Rodal Shah, then Neelamani Behra, then you have public interest litigations were developed as various judicial tools to protect the fundamental rights. And of course, that's why Indian Supreme Court is far ahead than many other courts in the world. So now Indian Supreme, after Justice Marshall's judgment in Marbury versus Madison, the judgment in Keshwananda Bharati is considered as a total expression of judicial craftsmanship. Because in a parliamentary democracy, parliament was supreme. So we adopted parliamentary democracy. There is a saying regarding powers of Britain Parliament. Britain Parliament has any power except changing a man as a woman, woman as a man. Except that all the powers on the earth, Britain Parliament could exercise. When we took the model from that, and under that influence, when there were constitutional amendments were brought, of course, for the goodness of the people, for the welfare of the people, but the Supreme Court of India, of course, made a first attempt in Golaknath just to restrict the power of the amendment power to the extent of other provisions of the Constitution excluding fundamental rights. Fundamental rights could not be amended as per Golakanath. Then in Keshavananda Bharati, we have basic structure doctrine. So the judgment is acceptable, but court could not give the reason for the judgment in Keshavananda Bharati. Because in a parliamentary democracy, how can you restrict how can a nominated body restrict the elected body, which is considered as the constituent body? So Supreme Court of India in Quilly versus State of Tamil Nadu, when 50% excess reservations were provided and kept in 9th schedule, was able to give proper answer for creation of basic structure. There the Supreme Court says, Supreme Court is made as the chief custodian of the fundamental rights. In the protection of the fundamental rights of the people, Supreme Court can develop any jurisprudence. Because you have Article 141, law declared by the Supreme Court of India shall be binding on all the other courts. You have Article 142, to do complete justice, Supreme Court of India can declare anything as justice. So there Supreme Court was able to answerable to the critics of creation of basic structure. Now nobody can object for that. And regarding the judicial appointments also, until 1993, the executive appointment process simply was acknowledged by the courts. When President, of course, President of India in normal times means President of India and his cabinet. When his cabinet, President of India suggested some names to be included as judges, it is only for information to the Chief Justice. But for the first time, the court objected that process, and the consultation is not mere consultation. Before appointment of the judges, President of India should have an effective consultation. In the process of effective consultation, in order to give the advice, collegium practice was developed. Now the senior most judges of the court, constituted as collegium, can recommend the names. So that all these are there, which are developed as part of constitutional jurisprudence, just to face the constitutional fundamentals. Now you take a recent judgment, particularly regarding challenging of socialist and secular words. Initially, we the people of India, having solemnly resolved to constitute ourselves into a sovereign democratic republic. By 42nd Constitutional Amendment in 1976, the two words were added. Now Subramanya Swamy and others challenged that particular two words. Original Constitution has no those words. So now they wanted to remove those two words. Then simply the Supreme Court in the recent judgment said that socialist word was reinterpreted in a dynamic way. Socialism not in the light of Fabian socialism of Nehru or this other socialist countries practice. Socialism in India, understood by Supreme Court of India, is removal of inequality from the society. So there is no wrong containing the word socialist. Secular, equality of religions, samadharma samabhava. So secular is also not an objectionable word. Both were constitutionally upheld. So that's why wherever there is a challenge to the constitutional fundamentals, if you are aware of this story of this basic structure. So Madam Gandhi, in order to dilute the judgment of Golaknath, brought various amendments which were challenged in Keshavananda Bharati. So it is 7-6 judgment. So the moment judgment was given, Chief Justice Sikri retired. So Madam Gandhi, who was not liking the judgment, first time superseded 3 judges. Justice Shalath, Justice Hegde, Justice Grover. Appointed fourth senior most judge, Justice A.N. Ray. And of course, by the time of Indira Gandhi versus Rajnarayan, when 39th constitutional amendment was challenged, the court understood the value of basic structure. Those who opposed basic structure in Keshwananda Bharati accepted basic structure in Rajnarayan case. They simply said that just, fair, free elections are the part of basic structure. So giving preference to President of India, Vice President of India, Lok Sabha Speaker, Prime Minister, elections, which were given immunity under 39th Constitutional Amendment, which cannot be challenged in any court on any ground. That was struck down. So the Supreme Court of India evolved basic structure. In Minerva Mills case, Supreme Court understood that harmonious construction between fundamental rights and directive principles is part of basic structure. And in Bombay case, secularism is basic structure. And like that, the court is evolving new concepts to be included in the basic structure. Of course, in 1993, when I attended a conference in Delhi, for which it was a conference organized by National University Bangalore and Delhi Bar Association, which was held in Delhi. For 5 days, Justice Krishna Iyer, Madhav Menon and all these people were there in the venue. And in one occasion, Justice Krishna Iyer shared the experience of the constitution of 15-judge bench to overrule the Keswananda decision. Madam Gandhi invited Krishna Iyer for breakfast. And in the discussion, Madam Gandhi requested Krishna Iyer, you please cooperate with Justice H.M. Beg. Second time, seniority of H.R. Khanna was superseded by Madam Gandhi government. M.H. Beg was appointed. Beg wanted to constitute 15 judges constitutional bench to review the judgment of Keshwananda Bharat. Then Krishna Iyer advised Madam Gandhi, today you will be there in the Prime Minister post or tomorrow you may not be. But basic structure is the life of the Indian Constitution. Don't make attempt to dilute the doctrine of basic structure. Then she dropped the idea, and when she came to power again, if you observe the Madam Gandhi's tenure until her assassination, she never interfered in the judicial process. Her government was more critical about the role of judiciary from 1967 to 75. All these periods, the government had a direct tussle with the judiciary. When she brought abolition of privy purses in the name of property, judiciary objected. When banks were nationalized, judiciary objected. So regarding the amendment of fundamental rights, giving preference to directives, when 31C originally constituted through 27th, which was challenged in Keshwananda Bharati. Of course, H.R. Khanna accepted the first part. In order to implement 39B and C, if any legislation is brought, even though that legislation is violative of Article 14, 19 and 21, it was valid. That was challenged, no judicial review. Then Khanna observed that first part you can provide, but excluding judicial review is violative of basic structure. Because judicial review is part of basic structure, every legislative action or executive action should be judicially scrutinized to get the validity. Then Madam Gandhi again made an attempt to amend Article 31C in the place of implementing 39B and C. 42nd Constitutional Amendment says that in order to implement directive principles of state policy, if government brought any, parliament brought any legislation, state government brought any legislation, even though that legislation is violative of 14, 19 and 31, it was not invalid. Justice Chinnappa in one of his judgments mentioned that when Article 31C comes, Article 14, 19 go out. But in Minerva Mills case, in order to maintain the balance, the newly amended article was struck down. The original 31C giving preference to 39B and C over fundamental rights was valid, upheld valid, whereas the newly amended article to give preference to all the directives was objected. So newly amended article was struck down in Minerva Mills case. So like this, whenever there is a challenge to the constitutional fundamental, the court raised to the occasion. The court now is creating various new tools. So you have just mentioned public interest litigation, and particularly to protect the environmental environment in the country, various principles were evolved. The international principles developed were adopted into the Indian environmental jurisprudence. So regarding this type of constitution, even election commission was controlled several times by the judiciary in order to ensure just, free and fair elections. So that's why regarding the protection of constitutional fundamentals, judiciary is upholding the constitutional culture. That's why constitutional morality, and judiciary is accountable to the constitution. That's why what is constitution at present India? No doubt, constitution of India in text. But how it is understood by the judiciary in contextual manner, contextual understanding of constitution is the real constitution in India now. Article may be there, when differences of the articles may be there, but in order to promote the constitutional legitimacy, Supreme Court of India may strike down some of those for the strengthening of constitutional culture, constitutional morality, constitutional philosophy, which was envisaged by our forefathers. So that's why recently, a recent development regarding, it is very interesting, recently what we have, recently a new interpretation Justice R.S. Chauhan wrote an article on 14th February 2023 regarding artwork in the Constitution and myriad interpretations. Even now, our Constitution has been handwritten, and different scriptures, different pictures were given. While coming from Sri Lanka to Ayodhya, Ram, Lakshman and Sita in a chariot was given. And this Bhagavad Gita, preaching of Bhagavad Gita by Lord Krishna to Arjun was given. So Buddha was given, and even Tipu Sultan, Jhansi Lakshmi Bai, all these were given in different places of the original constitution. Now different interpretations are coming to those piecemeal pictures provided in it. So even some Supreme Court, Allahabad High Court judges and some other judges try to understand the constitutional text in their own contextual way, taking the help of these. So these pictures are also to be interpreted in a secular way. So what is the constitutional fundamental? So you cannot have a piecemeal interpretation of a particular picture. You should have a contextual one. And particularly, the 10 judgments which changed the constitutional course, particularly Keshavananda is there, Manaka Gandhi is there, and Shabonu case is there, Volga Tellis is there, and Union Carbide case regarding Bhopal gas tragedy, and regarding reservations I touched about Indra Shahani. Then post Indra Shahani also tried to implement Neelamani Behra and SV Supreme Court advocates on record regarding the development of the collegium system, and Vishaka case regarding the protection of women's rights at workplace, and particularly this euthanasia, where the life is to be, the death is to be accepted. So all these are the major cases. Of course, these cases are many other cases also set the precedents to strengthen the constitutional culture, constitutional morality, which are all component of constitutional jurisprudence developed by the Indian judiciary, taking note of various other experiences also. So, Madam, in her last words, she, in her speech, mentioned about Sachidanand Sinha's comment about the Constitution of India. And of course, Rajendra Prasad also made a comment about the function of the Constitution. But always it is relevant about the statement of Ambedkar regarding the working of the Constitution. However good a Constitution it may turn out to be bad if the people who are called to work upon it are bad enough. However bad a Constitution it may turn out to be good if the people who are called to work upon it are good enough. So, if at all failure is there, failure is not the part of Constitution. Constitution is not the failure. If at all failure is there, it is the failure of the people who are called to work upon it. Maybe a legislator, maybe an executive, maybe a judge. So that's why we have to understand the value of Constitution, which is a backbone for protecting the Indian democracy. Thank you very much for giving me this opportunity to share some of my thoughts. Thank you very much.
Thank you, sir, for your enlightening lecture. Now it's time of releasing our Law Journal. So I request our principal, Professor Dr. Joe Joseph, sir, to hand over to our esteemed guests to release the Law Journal. Now I invite Professor Dr. Joe Joseph, sir, Principal CSI College for Legal Studies, for felicitating a token of love to Professor Dr. D. Surya Prakash Rao, Honorable Vice Chancellor, Damodaram Sanjeevaya National Law University, Visakhapatnam. As a part of Navomy's memory, her family is providing an endowment award and cash prize for first semester toppers of every batch. So I hereby invite the achievers to come forward and receive the awards. Academic year 2021-2022, Miss Jarina A. Joshua, 5-year integrated BA LLB honors. Miss Janita Jojo, 5-year integrated BCom LLB honors. Academic year 2022-2023, Mr. Lino M. Varghese, 5-year integrated BA LLB honors. Ms. Hridya K.N., 5-year integrated BCom LLB honors. Academic year 2023-2024, Miss Steffi Maria Sinoj, 5-year integrated BA LLB honors. Miss Aditya Suresh, 5-year integrated BCom LLB honors.
It's time to present awards for the laurels of our institution. Our institution has been holding ranks for the golden years. Now we have the honor of recognizing our university top achievers. I welcome all university top achievers to the stage. First rank Lakshmi Priya, BA LLB honors, has secured first rank in the MG University, BA LLB honors. And Anne Teresa Sebastian has secured 5th rank in BA LLB honors. In her absence, I request Meghana to come forward and receive the award. Betsy George has secured 6th rank in MG University in the BCom LLB honors. Next, 8th rank was secured by Avancia Claria, BCom LLB honors. Ninth rank was secured by Gobiga H.A. BA LLB honors. Thank you all achievers for upholding the prestige of our institution. Thank you.
Now I invite Professor Dr. Joe Joseph Sir, Principal CSI College for Legal Studies, for felicitating a token of love to Professor Dr. D. Surya Prakash Rao, Honorable Vice Chancellor, Damodaram Sanjeevaya National Law University, Visakhapatnam.
Now I invite Professor Dr. Joe Joseph Sir, Principal CSI College for Legal Studies, for felicitating a token of love to Professor Dr. Bismi Gopalakrishnan, Registrar, MG University, Kottayam.
As a legal professional, he has played a pivotal role in serving justice fairly and effectively, standing as a beacon of integrity and righteousness in a judicial system. I invite former district government pleader and public prosecutor Kottayam Advocate Sunny Joe Chathakulam for felicitation.
Good afternoon. First of all, I would like to offer my praise and paying homage to Navomy. തോമാച്ചൻ ചേട്ടൻ്റെയും എൽസമ്മ ചേച്ചിയുടെയും മോക്ക് വേണ്ടി ഞാൻ പ്രാർത്ഥിക്കുന്നു. റെസ്പെക്റ്റഡ് ചെയർമാൻ ഓഫ് ദിസ് മീറ്റിംഗ് ജിജി ജോൺ ജേക്കബ്, ട്രഷറർ CSI മധ്യ കേരള ഡയസിസ്, Professor Dr. Vishmi Gopalakrishnan, Registrar MG University, who inaugurated this auspicious meeting, Professor Dr. Surya Prakash Rao, Honorable Vice Chancellor, Damodaran Sanjeevana, National Law University, Visakhapatnam, Dr. JCT, Dr. Kosi Abraham, Dr. George Joseph, the principal of this law college, respected lecturers of this institution, the parents of Navomy and Thomachan and Ilsamma, and all my dear students, ladies and gentlemen. I begin with a good afternoon. Now time is already over. It is going to be 12:30, and we had an excellent exposition of the grammar of the constitutional interpretation. The grammar of the constitutional interpretation and the changing times with regard to the constitutional fundamental, already exposed by Professor Dr. Surya Bhaskar Rao and Professor Vishmi Gopalakrishnan. I am not taking much of the time. As far as I am concerned, it is a homecoming. Your principal, Dr. George Joseph, is my native man, and JC is my student. And I had worked with Dr. Vishmi Gopalakrishnan while I was a lecturer, guest lecturer at the School of Indian Legal Thought. Some of you may enter into the legal field with much stress and strains. What would be the outcome? As far as I am concerned, after postgraduation from MA Economics, Mastering in Economics, I joined for the LLB studies in School of Indian Legal Thought. From 1997 onwards, I had been working as a guest lecturer therein. Meanwhile, enrolled in the year 1994, and I occupied a pivotal role in the Indian judicial system in the sense that conducting cases for the government as a public prosecutor therein. Last December, I resigned as a public prosecutor and district government pleader. In my opinion, you have no doubt to fear. You can vehemently, darely enter the field and enroll as an advocate or do your research, or in many ways, myriad ways, you can prove your mental concern. I want to make some discussion with you with regard to the topic of constitutional jurisprudence. First of all, this jurisprudence is the philosophy of law concern. As far as law students are concerned, all this jurisprudence is a very, very, very difficult topic. What exactly Constitution Kelsen, in pure theory of law, mentioned a term, grundnorm. Those who studied jurisprudence, some of you are first year students, the students sitting before me are first year students. They have only pre-law subjects may be there, so they haven't entered into constitutional paper. So jurisprudence is a very difficult to study. But a constitution is somewhat easy. So interpreting the constitution in tune and tenor with the present time is the importance of this topic. That is very excellently exposed by the Vice Chancellor concerned. Now, since it is the grammar of law, grammar of the constitution, why this such a written constitution is received by us, dedicated to us, and our Supreme Court is implementing the various provisions of the constitution. The first purpose, as far as I am concerned, to lay down some institution which are accountable to the people. Accountability must be there. You know, we have a right to govern ourselves. From the evolution, going through the various theories of social contract, we have a right to govern ourselves our right to govern ourselves is surrendered, submitted to a larger authority. In the Rousseau's word, it's a larger will. So it's a social contract in the words of John Locke. So our right to govern ourselves, by going through the Human Rights Declaration, when every man is born, when every child is born, he is possessing an unbridled right to govern himself. In some way or other way, that rights were curtailed, that rights were infringed. So we dedicate our rights to a larger authority to control our wishes. I am coming into the point that as very well mentioned by Professor Vice Chancellor, some of the important areas in our constitution was implanted in the body. Our fundamental rights, our parliamentary system of government and judiciary, the concept of judiciary was borrowed from the English constitution. You can also see the fundamental rights, the very important topic in our constitution is borrowed from the American constitution, the American setup, and the directive principle from the Ireland. You know, there is no written constitution in the English setup. There are only customs, precedents and practices. All you are aware about what happened in 1215. King John was compelled to sign the Magna Carta, the Bill of Rights, the rights of the person. There is no tax. The people, the lords hesitated to pay tax if there is no representation. So there are certain institutions in our constitution, in our country. You take the parliament, the legislative, the executive, all the most the judiciary, which is the guardian of the rights, fundamental rights, not only fundamental rights, but other statutory right of the people concerned. So constitution is supreme. The second purpose for which a written constitution was adopted by, a written constitution was received by us, in the sense that to act as a dictator to the arbitrariness of the governing authorities. So there comes the role of natural justice. Everyone must be heard. An opportunity of hearing must be given. I am not going to divulge over the recent decision of the Supreme Court. Already our Vice Chancellor has exposed it. You take the Maneka Gandhi's case, you take Ekagoval's case, you can see the principle of natural justice. An opportunity should be given, whether it is in the labor law, whether it is in the Bar Council's Advocates Act, whether in every other act, an opportunity of fair hearing must be given. So, when our rights are violated, when this is violated, what is the remedy? You can approach the Supreme Court or the High Court, either under the Article 32 or under 226 of the Constitution concerned. Now, coming into another important respect, some ideals must be set up in the Constitution. That ideals we can see very well in the directive principles of the Constitution, which we borrowed from the Ireland Constitution. So even though there is no written constitution, the American, the parliamentary form was exactly implanted in our body politics, in which a society contains heterogeneous nature of the people, people speaking different languages, people following different customs. And you know, at the time when Indian Union was formed, 556 princely states were surrendered their right to governed by a union of India. A unitary form is therein. Then at the same time, the federal structure is retained. We have Kerala, the state is divided, formed on the basis of the linguistic, on the basis of those schools speaking languages. So we can see the cultural diversity, we can see the linguistic diversity, that is like the one code, that the union of these countries, union of the state, which formed the Indian Union concern. Then the rights of the individual is very well zealously guarded therein. You know, Article 39, several directive principles. What is the implication of this directive principle? This directive principles act as a direction. It is the legislature, it is the parliament to give effectiveness to directives. Earlier, right to education was not a fundamental right. In Mogri Jain's case, Supreme Court very well explained that right to education is a fundamental right by expanding the horizon of Article 21. Article 21, even though the provision says that the liberty cannot be curtailed without a procedure established in law, it encompasses the all rights of the human beings contemplated under the Article 14, Article 19, and Article 21 concern. I am not taking much of your words. In a Marbury versus Medicine, while analyzing Article 14 of the US Constitution, Justice Marshall said that the duty of the court to declare what law is. So there is the duty of the court to declare what the law is, what the law as it is. So whenever there are any infringement, suppose a state make a law against the Constitution, that cannot sustain. That is void ab initio. No state has a right to make any law against the Constitution. The Constitution is supreme. So it is not a liberal interpretation. That is not contemplated under the interpreting the Constitution. Just like in some criminal statutes or in taxing statute, an interpretation which is capable of the accused must be taken. Or in a taxing statute, interpretation which is having double meaning, it should be in favor of the associate should be issued. But in keeping the central-state relationship, even though interpretation seems to be liberal as far as 7th schedule is concerned, it is not so liberal. I am winding up my words, extending my thanks to this CSI Law College for inviting me to address this gathering, extend my felicitation. My actual role is to extend my felicitation, and I am winding up. I want to say one more thing. During my tenure as a district government builder and public prosecutor, some of you approached my office for doing apprenticeship. And it is my being a guest lecturer. I was a guest lecturer for the School of Indian Legal Thought since 1997 onwards. I put questions regarding CPC, CRPC, Evidence Act, and IPC. And these people are rather fairly doing well. And they are also very disciplined also. Very disciplined in the sense that they appear in the uniform. They appear before the court in the uniform. They attend the court procedure. That is a welcome step. And that shows the progress of this institution. Even though the school was instituted in the year 2013, it made a golden mark in the Kerala Judicial, in the Kerala Legal Academic Circle. I am very much thankful to Professor George Joseph and JC and the CSI management and Thomas Matthews family for giving an opportunity to addressing this gathering. Thank you very much.
Thank you. Thank you, sir. Your presence here today is a testament to your assuring commitment. Your insights and encouragement have always played a crucial role in sharpening our minds and fostering our environment and growth. I invite Dr. JCT, Vice Principal, CSI College for Legal Studies, for a vote of thanks.
Good afternoon. Honorable Chair, Reverend Gigi John Jacob, Professor Dr. Surya Prakash Rao, Honorable Vice Chancellor, National Law University, Visakhapatnam, Professor Dr. Bismi Gopalakrishnan, Registrar, Mahatma Gandhi University, our Principal, Professor Dr. George Joseph Sir, Advocate Sunny George Shatugulam, our Best Sir, Koshi Abraham Sir, and parents of Navomy and Sri Rajesh Sir from University, and our teachers, guests, and the students and all of you present here. It's my privilege to honor to propose the vote of thanks on this occasion of the 7th Annual Law Lecture and Navomy Endowment Award Ceremony. First and foremost, I thank the Almighty God for blessing this event with success. I extend my gratitude to Professor Dr. Surya Prakash Rao, Honorable Vice Chancellor of Damodaram Sanjeev National University, Visakhapatnam, for gracing us with his esteemed presence and delivering an enlightening lecture on the theme, Evolution of Constitutional Jurisprudence for Challenges to Constitutional Fundamentals. Your insightful words have left an impression on all of us. Thank you, sir. I express my thanks to Dr. Sujata ma'am, the wife of Dr. Surya Prakash Rao, for your gracious presence. Thank you, ma'am. A special vote of thanks and gratitude goes to Professor Dr. Bismi Gopalakrishnan, Registrar of Mahatma Gandhi University, KOTTAYAM, for delivering the inaugural address, and inspiring with her words of wisdom. Thank you, ma'am. I would like to express my sincere thanks to Reverend Gigi John Jacob, Treasurer CSI Madhya Kerala Diocese, for presiding over this function and sharing his thoughtful remarks. Thank you, Father. I would like to express my thanks to Professor Dr. George Joseph, Principal, CSI College for Legal Studies, for introducing us in the significance of this annual law lecture and Navomy Endowment Award. We are immensely grateful to Advocate Sunny George Chathugulam, former district government pleader and public prosecutor Kottayam, for his presence and felicitation, which added great value to this occasion. Thank you, sir. This ceremony would not have been complete without remembering Navomy and Thomas, our beloved student who left us and now in the eternal rest in heaven. Her memory continued to inspire us, and today's award is a testament for her enduring legacy. I would like to extend our deepest appreciation for her parents for instituting this event, this endowment award, and thanks to Mr. Thomas Matthew Ottatail and family. I would like to extend our congratulations to the awardees of Navomy Endowment, our student Janita Jojo and Jarina Joshua of 2021-22 batch, and Aditya Suresh and Steffi Maria Sinoj of 23-24 batch, and Hridya Kane and Lino M. Varghese 22-23 academic year. I would like to congratulate the students who have secured the highest mark in the first semester university examination, and you have made us all proud with your academic excellence. Thanks to all of you. A special thanks and heartfelt congratulations to our rank holders. And the first rank holder of BLLB honors, Lakshmi Priya, fifth rank holder Anne Teresa Sebastian, and sixth rank holder Betsy George, and eighth rank holder Avencia Claria, and ninth rank holder of Gobiga H.A. You are true ambassadors and shining stars of our college. May God bless you all with success and fulfillment all your future endeavors. Our appreciation goes to Mr. Koshi Abraham, our bursar, for his warm welcome address. Thank you, sir. Then I express special thanks to media persons, photographers, and Flash TV YouTube Live for live streaming this program. And thanks to our students, Remya Susan Samuel and Grace Mariam Lucas, for beautifully comparing this program. And thanks to our student, Vani Devi, who lead us in prayers by the prayer song. A heartfelt thanks to all our family members, staff, faculties, and students who work tirelessly to organize this event and make it a grand success. Your dedication and teamwork are truly commendable. I'm also grateful to all the guests, dignitaries, and attendees for sparing your valuable time to join with us. Special thanks to Rajesh sir for coming here from the university. Your presence encourages and motivates us to strive for excellence in legal education. Thank you all once again. I extend my gratitude to everyone present here. Let us conclude this ceremony by standing for the national anthem.
Thank you, ma'am. As we conclude, let's stand together to sing our national anthem, a powerful symbol of our freedom and unity of our nation.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Remember, every step you take today is a step towards bright future. Let's make every moment count and shape our destiny. Thank you everyone for being part of this event. Wishing you all a wonderful day ahead. Thank you.